What we're going to talk about today is ARS 13911. This is a new law, new on the books of Arizona. It's a very major law for a number of reasons. So let's talk about generally what this law covers.
Sure. Good morning, Phil. So 13911 went into effect in January of 2023. And before that, Arizona was kind of unique because there was no way, if you had gotten yourself in trouble, to have your records expunged, meaning you couldn't get your records erased from public view. But starting this year, we now have basically an expungement statute, even though they're not calling it that. And the 13911 applies to not just people if you got arrested and your case got dismissed, but if you were convicted of a misdemeanor or of certain felonies and a certain amount of time has elapsed, you can now apply and have the court basically remove that from the public record. On top of that, the Arizona law allows you, if you're filling out, say, a job application, to say if the expungement has been approved that you have never been convicted of a crime. And that's a big deal because, as everybody knows, it's a lot harder for convicted felons or people, if you've been convicted of a domestic violence offense, to get a job or to get into a renter. It affects your credit. There's lots of ways that this really negatively impacts people, and this is really going to help people.
Okay. So can you talk a little bit as to the conditions of under which you can require or request an expungement of arrest?
Sure. So, well, let me give you a little bit of the backstory. So prior to this law going into effect, we had on the books that was 134051, and that was just a sealing of arrest. But for that, you had to prove that you had been wrongfully arrested or that there had been some sort of major constitutional violation during your arrest. And so it was a really high bar, and I was one of the few people in the whole state of Arizona that was doing them, but it was really hard to do them because you had to actually show that, for example, that the police had arrested the wrong person, or that there had been some major Fourth Amendment violation during your arrest. And the courts were really reluctant to do that, to provide that kind of relief for people, and so they were hard to do. This basically allows, if you were arrested and the case was dismissed, it's available for everybody. You don't have to wait. There's no time period. There's just basically some statutory requirements of the things that you have to provide to the court, like your name, your date of birth, the case number, and anybody can apply to these things. And my experience that I'm having so far is that if you've been arrested and the case was dismissed, the courts are approving those. So it's a relatively easy, streamlined process now to get your arrest basically expunged if the case never went any further than an arrest.
Can you talk about an exception case, like you as a criminal defense attorney, you took up a case where the person had been, in your estimation, wrongfully arrested, and you brought the case before the court?
So, interestingly enough, it was 2 days ago, I was out to dinner with a bunch of friends of mine, and I walked in, and I had not seen this person had to be at least 15 years. And he was the manager of the restaurant. And he had a situation where he had been taking a nap. He was not getting along very well with his wife. And she was mad that she came home and she thought he should have been awake and doing a better job around the house. And she came in and she kicked him. And he was really mad. And he woke up to having somebody kicking him. He got up, they started yelling, she called the police, and when the police came, which happens more often than not, they arrested him and not her. And really the main reason why he was arrested was because he was a man. So when we took his case to trial, he was acquitted. And afterwards, he wanted to get the arrest off his record. He worked in a business with hotels and restaurants, and this is the kind of thing that would have really impacted his career. And so we filed to have his arrest basically sealed under 134051. And the court found that basically he never should have been arrested. He was actually the victim in this case, and that there was no reason for the police to arrest him. I hadn't seen this individual for a long, long time, and I walked into the restaurant, and it was very sweet and emotional. Like he came running up to me. He gave me a hug. He was like, "You changed my life. You saved me." It worked out great for me. I looked like a hero in front of my friends, and he comped my meal. So it was sort of like a really funny situation. But the truth of the matter is that he subsequently went through a divorce. His wife wasn't able to claim that he had been domestic, abusing her. In fact, they weren't able to, despite trying, they weren't able to use that whole case against him in any type of custody case. So he was able to have shared custody of his child, who's now a teenager. He has had a great career. His life was not impacted by a situation that was horribly unfair, and it shouldn't have been impacted by it because he didn't do anything wrong. Without that old statute, in all likelihood, this could have impacted his custody case. It could have impacted his career because people go on, they do background checks, and they see this person was arrested for domestic violence, and boom, they jump to all sorts of conclusions about this person's character that weren't merited by the circumstances. So that was a great example of one of those situations, and it was, to me, as I've been doing this for over 20 years, to see how much these things actually really impact people.
It's an interesting case, definitely. Let's jump to the conviction side. What does the law cover in terms of expungement of convictions?
Sure. The main thing is a waiting period. There's two things. There's certain charges that you cannot ever apply to have them cleared or expunged. Okay? But the main thing is the vast majority of the charges, okay, that you have to wait 10 years for a class 2 or 3 felony, 5 years for a 4, 5, or 6, 3 years for a misdemeanor, class 1, and 2 years for a class 2 or 3 misdemeanor. So let me talk about what a class 2 felony would be, like a kidnapping. A class 3 would be like an aggravated assault if you were convicted of pointing a gun at somebody. A class 4 would be a prohibited possessor. Class 5 could be an endangerment. A class 6 could be a drug charge. Class 4 could be a drug charge. Class 1 misdemeanor is usually the real standard one is domestic violence, disorderly conduct. It's a class 1 misdemeanor. Class 2 or class 3 misdemeanors are much lower misdemeanors, so there's not as long of a wait. So the big thing is the wait. The other part is that there are certain charges that you cannot apply to, and those are basically what you're looking at would be dangerous nature offenses. Okay, if you committed a homicide, you can't get that ever sealed. Okay, you cannot apply if it involved child abuse. Okay, you cannot apply if it involved a burglary, and so when I look at the statute, is you can't apply to this if you had been convicted of a burglary or a theft and you're applying for a job that requires entering into or performing services inside of a residential structure. So some of this stuff kind of makes sense. So if you got convicted of a burglary and you want to have a job that, to be working as a plumber where you're going to be going in and out of people's houses, they want the public to be able to know that that's what your history is. If you are involved in a situation where you're teaching minors, you can't apply if you've been convicted of child abuse because they want to be able to tell that people that are teachers or providing care for minors don't have the ability to hide that from the public. Okay, so most of this stuff is pretty common sense, but for the vast majority of people, if you were convicted of a crime, you can basically get that record sealed.
Okay. So let me ask you a question as an attorney. What do you think do you think that this law is going to be expanded going forward? Do you think it's going to be refined, that the legislators will expand its purview, and there's going to be kind of a willingness from the legislator to allow for more exceptions and more like a wider field of application?
I think that's a good question, and I think it's pretty tenuous about that, because all it takes is one person who had their record sealed to go out and do something terrible, and the public is going to revolt. So I think time is going to tell, but if you end up with a situation where someone had their record sealed and that person goes and does something horrible like a school shooting or something like that, I think the public is going to be like, why the hell are we doing this?
Okay, Jake, thank you very much for giving us some detail on this law. Where can people reach you?
Sure. I maintain a web presence, and that's or you can email me, and that's Jake@Defense Law Tucson, or you can call me on the phone, and we've been getting a lot of calls about this, and we're working on them, and our turnaround time usually takes about 6 weeks to 2 months to get this thing done for people.